Hello, and thank you for joining us today. My name is Young Ki Hong, and I'm a senior associate at Scar Legal PC. Today's webinar will focus on how to obtain a green card-based company sponsorship. We are very lucky to have our firm's partner, Kelly Wiener, as the speaker for this presentation. Kelly has been invited to speak on similar topics at various immigration associations and professional organizations, sharing her expertise with both attorneys and business leaders. So before we dive in, let me briefly introduce our firm and go over a few housekeeping items. We are full service immigration law firm, and we offer services in a wide range of areas, including E2, O1, TN, L1, H1B, and any types of employment or family-based green card cases. That said, we are especially well known for our excellent work with the employment-based green card cases, and we have built a strong reputation throughout many years of experience. We have processed thousands of these types of cases. Many of them were complicated cases, but we were still able to secure approvals for the majority of these cases. At the end of this webinar, we'll send you several useful tools. A copy of the PowerPoint presentation we'll go through today, a link where you can download the guidelines with more details on visa options, a link to sign up for additional webinars, a link to webinar recording on YouTube. We strongly encourage you to subscribe and hit the notification button as we regularly post immigration-related videos. And lastly, a link where you can set up a private consultation with us. So finally, for any questions, please type them into the chat box or Q&A box. We'll address all the questions at the end of the presentation. And with that, let's get started.
Thank you. Thank you, Yankee. So today we're going to talk about employment-based green cards with a focus on the PERM process. We've listed here just kind of a few of the other employment-based, options, and kind of we'll briefly discuss them. We do have other webinars that go over these in more detail. So, for example, the EB-1A, extraordinary ability, for people who have, reached sustained national or international acclaim in their field of expertise. This is also a great option because you can self-petition. You don't need a company sponsor. We have the EB-1B for outstanding researchers or professors, often people who are coming to hold tenure track roles in the United States. The EB-1C for multinational managers or executives. Sometimes these people enter on L1 visas, as managers or executives, and then go on to get green cards. Although you can also just apply directly for the green card if you qualify for that. The EB-2, you qualify for this by having either an advanced degree, which means a U.S. master's degree or its equivalent or higher. Equivalent would be a U.S. bachelor's plus 5 years of progressive post-baccalaureate work experience. If you don't have a degree, you also can potentially qualify for EB-2 based on exceptional ability. This is kind of a lower standard than extraordinary ability, and you show that you meet 3 out of 7 criteria that are kind of all aimed at showing that you're someone who's kind of risen above others in your field. For the EB-2, there's 2 ways to qualify in this category. One is through the PERM company sponsorship, which we're going to talk about in detail later in the presentation. The other is through something called the national interest waiver. This is where you ask the government to waive the normal company sponsorship process, and you ask them to waive it on the basis of the applicant working in an area of substantial merit and national importance to the United States by proving that the applicant themselves is well positioned to advance that particular endeavor. And then you argue that on balance, it's beneficial to the United States to waive this normal company sponsorship process. Another is the EB-3. This is for, again, PERM company sponsorship, and we'll go into more detail about this later in the presentation. But this is for professionals and skilled and unskilled workers. The way that this is defined is a professional is where the job requires at least a U.S. bachelor's degree or higher. Skilled work would be requiring at least 2 years of education, training, or experience. And then unskilled work would be anything where the job requirements are under 2 years of education, training, or experience. EB-4, we won't cover. It's kind of a special immigrant category that covers multiple, different things, including, for example, green cards for religious workers coming from the R1. And then the EB-5, which is kind of, it's under the employment-based. It is kind of more of an investor green card. This is where you are getting your green card on the basis of investment and creation of U.S. jobs. So you invest either $800,000 or $1,050,000 and then show that you've created 10 full-time jobs. We also do have kind of separate webinars that go over some of these categories in much more detail. So if you do have an interest in any of these besides the PERM company sponsorship, I would encourage you to subscribe, check out our website and our YouTube because we do have more information on those categories in other webinars. All right, so let's talk about the labor certification process, also called the PERM process. And this is, under the EB-2 and EB-3, so employment-based green card categories. So as I kind of described on the previous slide, the difference between EB-2 and EB-3 is what does the job require? And then, of course, the applicant has to meet that requirement. So an EB-2, job is going to be one that requires either a master's degree or equivalent or higher, or where it requires exceptional ability. And EB-3 would be where the job requires either a U.S. bachelor's degree or at least 2 years of training or experience or education for skilled workers, or less than that for unskilled workers. A common misconception that people have is, well, I have a master's degree. Why was my case not filed, as an EB-2? And again, you have to think about what does the U.S. job require? So if you are applying for a job and the job only requires 2 years of education, training, or experience, and that's all they've ever required for it, the fact that you have a master's does not mean that this is an EB-2 case. The job, you have to have the master's, but the job also has to require the master's in order for it to be classified as an EB-2 job. So just putting that out there, I think it's a pretty common question that we get where people don't understand that you are really constrained by what the job requires. So the PERM process is a company sponsorship process. This means that a U.S. company must want to sponsor a worker for a green card for a permanent job in the United States. It is not an employee-driven process. So there's some green card categories like the EB-1A for extraordinary ability, or the EB-2 national interest waiver, where you have this ability for the applicant themselves to self-petition. That is not the case for the PERM, and it really is a company-driven process. So we'll talk about this a little bit later in the presentation too, but there's kind of policy and law kind of put into place to keep employees from kind of going to their employers and saying, hey, I will pay you to sponsor me for a green card. There's actual policy against that. So kind of another common, issue will come up where employees will kind of, schedule a consult or want to say, well, if I just pay my employer says they'll sign whatever I give them. If I just pay them to do it, can that work? And the answer is no. And you'll see we'll talk about why there's certain fees the employer is required to pay. And the reason is to prevent this type of situation where they do not want, immigrants kind of paying employers to sponsor them. All right, so the PERM is a 3-step process. The first is by far kind of the longest, so that's the actual PERM. The second is the I-140, and then last, the I-485 or consular processing. That is the green card step. That's that third step. So for the PERM, the first thing that you have to do is draft a PERM compliant job description. And this is a bit different from a normal job description. A normal employer is going to put out a job description that asks for kind of everything they want, great communicator, great team player, great communication skills. When you're doing a job description for the PERM, you have to ask yourself, what are the minimum requirements to do this job in a reasonable manner? And then you draft the job description based on that because they want, the government wants this job to be as open to any U.S. worker who is qualified as possible. The entire process is very protective of the U.S. labor force. They essentially want the employer to be able to prove, okay, if you want to hire this person, you need to prove there are not any willing, qualified, and available U.S. workers in the labor market to hold this job in the area where you're advertising for it. So once you've drafted that job description, you also have to keep in mind, what does the applicant have, right? So if you're saying, well, this job requires, a master's and 15 years of experience, and the applicant does not have that, that's not going to work. So it is a matter of kind of considering what experience does this person have? What are the true minimum requirements to do this job in a reasonable manner? And can those be aligned? And that's what it has to be, before you, finalize your job description. Once you finalize the job description, you're going to file a prevailing wage determination with the Department of Labor. So this is where the Department of Labor will assess the job duties, the job requirements, the location, and they will assign a level, so level 1, 2, 3, or 4 for the job, and then also the wage. And the wage is going to be what the employer has to pay once the applicant actually gets their green card in the future. So again, a common misconception people will have is, well, they currently work for me. If we get a prevailing wage, do I have to pay them right now? No, the prevailing wage is relevant when you actually get your green card in the future. Additionally, the employer can always offer more than the prevailing wage. And if they do, that's what they have to pay, but they must offer at least the prevailing wage to be able to proceed. Once you get your prevailing wage, you can start the actual labor market test, also called the recruitment process. This is where the employer is required to actually place advertisements. For a job that is, kind of less than a professional, so skilled or unskilled workers, there's kind of 3 places you have to place your advertisements, newspapers of general circulation, the state workforce agency, and a notice of filing at the physical location. If it's a job that requires a bachelor's degree or higher, you also have to do 3 additional mechanisms to advertise the job. And there's a list of 10 that you can choose from. Some are quite dated, things like radio or TV ads. Kind of newspapers, things like that. But you can still choose from that list of ads. Once the ads are running, the general labor market test, it lasts about 60 days. It has to be at least 30 days where the ads are running, and then kind of what we call this quiet period where maybe no ads are running anymore, or maybe only one ad is running. And, during this time, the employer has to interview any applicants who appear that they might be qualified for this job. If they do find anyone who is a U.S. worker who is willing, qualified, and available for the job, so, will accept the terms of the job, the salary, all of that, and they kind of can't be, eliminated, then the PERM process does have to stop. So you've tested the U.S. labor market, you have found there are willing, qualified, and available U.S. workers. The employer is, of course, not required to hire any of these workers, but it does mean you can't proceed with the PERM process. If, however, you go through the labor market test and the employer does not find any willing, qualified, and available U.S. workers, then you can proceed to the next step, which would be filing your labor certification with the Department of Labor. Now, the labor certification can either be certified, which means approved, it can be denied, or it could be audited. If it is audited, what this means is that they want you to send more information to document that you met all the compliance requirements for the labor market test. Sometimes they'll ask for kind of specific things, but as a general matter, they often want to see things like the resumes of the people who applied, any evaluation sheets you have explaining why they were not, qualified, documentation of your, recruitment efforts, so proof that you actually placed the ads, proof that you got back to any applicants in a timely manner. So documentation is very important during this process. And whether or not you are audited, the employer has to keep something called an audit file that has all this evidence in it, because the case can be audited for up to 5 years after you file your PERM case. And we do recommend you kind of keep it, indefinitely as this, proof. All of these forms I've been talking about, everything is being filed at this point with the Department of Labor, not with U.S. Citizenship and Immigration Services. In terms of timing, Timing has, increased over the years. Prevailing wages are taking about 6 to 7 months. The actual labor certification, those are taking somewhere between, 12 to 15 months. Unfortunately, right now during the government shutdown, the Department of Labor is not processing PERMs. They're not processing prevailing wages. The websites are shut down. So that is kind of something that's going to increase processing times across the board. Moving to the I-140 stage, let's say you get your PERM approved, you've made it through the labor market test. Now you're going to file your I-140. So at this stage of the process, the documentation requirement is much less. If you kind of planned appropriately during the PERM, it should be, hopefully relatively straightforward. The I-140 is the one step you can actually premium process in this three-step process. So you can actually pay the government an additional fee to get an answer within 15 business days. That can be an approval, a denial, or a request for more evidence. With your I-140, your employer is filing this saying, yes, I intend to sponsor this applicant, and here are my financial records proving that I can pay the prevailing wage or the offered wage, whichever is higher. Of course, the offered wage has to be higher than the prevailing wage or at the prevailing wage. So when you file this, you have to prove, the employer has to prove that they had the ability to pay the wage from the time they filed the PERM. So now that the PERMs are taking so long to be approved, you want to keep that in mind just in terms of checking the employer's financials, before you file the PERM, and then also checking them kind of during the process, just so that they understand they will be required to, provide this proof that they can pay the prevailing wage. During the I-140 filing, you will also include proof that the applicant themselves meets all the requirements in the PERM labor certification. So if the PERM required that the applicant have a bachelor's degree and 2 years of experience in XYZ skills, you'll need to provide proof of the applicant's bachelor's degree and proof that they had that experience in those skills, before joining the employer. Once the I-140 is approved, you get to the next step, which is the I-485 or consular processing. Right now, the EB-2 and EB-3 are backlogged worldwide. What that means is that the number of people applying for green cards exceeds the number of green cards available. And so there's not an ability to kind of concurrently file the I-140 and the I-485 for EB-2 or EB-3 right now. That being said, once your priority date is current, then if you're in the United States in a valid status, you can file the I-485. Otherwise, if you want to process abroad, you can go get your green card through consular processing. So when we say here timing current or not, again, you want to look at what is my priority date. Your priority date will be the date your PERM was filed. So in some ways, kind of having this really long processing time, by the time you get your PERM approved and your I-140 approved, hopefully your date is not too far from being current because you've already kind of been waiting for a year and a bit. Your family members can also apply with you. Your spouse and any unmarried children under 21 are the people that can kind of come onto your green card application with you. And we're going to talk more about the third step, the green card step, later in the presentation. Okay, perfect. So let's dig into the green card process, which is, I think, where everyone kind of wants to get to. So once you have kind of gone through this longer, maybe year, 2-year process of the PERM and the I-140, now you're finally at the green card process. And so once your priority date is current, which means there's a green card available in your category. So let's say you're in the United States on an H-1B. You can go ahead and file your I-485 with U.S. Citizenship and Immigration Services. This gives you kind of the ability to remain in the United States, while your petition is pending, even if your H-1B status lapses for some reason. You can also file for work and travel authorization along with the I-485. And then at the end of the process, you likely will have an interview with the USCIS officer. Sometimes they will just approve it based on the paperwork, but that's becoming less and less frequent, especially during this administration. One caveat, if you do have kind of that H-1B visa stamp or the ability to have a stamp, it's a good idea to make sure you have that valid stamp in your passport kind of before you file your I-485. This gives you the ability to kind of travel freely during the, adjustment of status process. While you can apply for advanced parole, which is the travel authorization, coming in on a parole status is less favorable than kind of maintaining that underlying H-1B status if you can. However, for many people, like if you're on an E2 or you're on an O, once you get once you file your I-485, you cannot travel on that visa. You will abandon your adjustment of status application if you do. So your only option if you want to travel during the pendency of the adjustment of status is that advance parole document. Generally low risk to travel, although, kind of in the latest environment, we have been cautioning people to really think about whether they need to travel. As coming in on parole, it is a discretionary decision to parole you into the United States. So kind of less, safe than having kind of that underlying visa status. If you're going through consular processing, so sometimes this is a good option for people, like let's say you have an E-2 and you just can't stay here in the United States and wait, 8 months, 10 months, a year for your advance parole to come through. You have to travel for work, family concerns. Then maybe you want to do consular processing as your option. Under this route, your approval of your I-140 is going to be sent to the National Visa Center. That usually takes maybe, a few weeks from the approval date for USCIS to forward that to the National Visa Center. Then you'll get a welcome letter. You'll fill out a DS-260 and kind of provide supporting biographical documents, civil documents, your birth certificate, marriage certificate, divorce certificate, police certificates for anywhere you've lived. And then you will attend an interview at the consulate. You'll also attend a medical exam with a panel physician. So this is like not your regular doctor. It's going to be a doctor that is specified by the consulate that you have to go see. And they will send those results generally to the consulate. You'll attend your interview. And if your case is approved, then your green card, what you'll get is an immigrant visa stamp in your passport, generally valid for about 6 months. You need to enter the United States while it is still valid, and you will be entered you'll get what's called an I-551 stamp. That says you are a legal permanent resident in the United States. You can use that as proof of the ability to work and travel. They usually put that in there valid for about a year, and then your green card is mailed to you after you enter the United States. Okay, who can pay for the green card fees? So a very common question, as I mentioned previously, there is kind of policy in place that prevents employees from being able to just pay for the whole process. So any fees that are related to the actual sponsorship process, legal fees and other fees such as placing the advertisements for the labor market test, these have to be paid by the sponsoring employer. You cannot offload these to the employee, and the employee cannot proactively say, I want to pay for these. Once you get to the I-140 petition and the green card petition, still recommended kind of for the employer to pay for the I-140 petition because it's their petition. That being said, for the premium processing for the I-140 or for the green card application, either the employer or employee can pay for these. Let's talk a little bit about dual intent. And so if you're applying for a green card in the United States, it's really important to understand what is dual intent, what visa am I on, does it have dual intent? So when you get a non-immigrant, also called a temporary visa to the United States, most of these visa types involve the applicant explaining they do not intend to be in the United States permanently. So if you're getting a tourism visa, if you're getting a student visa, if you're getting a TN work visa, these all have requirements that the applicant demonstrate they do not intend to work or to come to the United States permanently. They have a residence abroad that they do not intend to abandon. There's some other visas where the standard is a little bit lower. For example, for the E-2, or the O, like there's kind of language that will say, well, the kind of even having an immigrant petition filed doesn't mean you can't meet the standard for proving that you are here temporarily. So there's ones where it's a little bit more malleable. And then there's visas like the H-1B and the L, where it's extremely clear in the regulations that for these visa types, it is completely fine to both be on your temporary visa and also have an immigrant petition pending or an adjustment of status pending. We've listed O here under dual intent visas, even though it's not quite as clearly a non-immigrant or a dual intent visa as the H-1B and the L. There's kind of a lot of favorable language in the Foreign Affairs Manual and in the regulations that describes, the O1 as saying that, you can kind of still continue to get the O, even if you do have, an immigrant petition, which is a permanent petition. That being said, definitely like kind of more favorable to be on an H-1B or an L when you're going through the green card process, if that's available to you. Although it is possible to go through the green card process with a visa like the O, like the TN, but there's just more risk and more careful planning you have to do. All right, let's talk about timing and underlying visa status. So when you're going through the green card process, you want to kind of look at what is my current visa, how much time is left on my current visa. Some visas are going to be really much harder to extend or subject to more scrutiny once an I-140 or a green card petition is filed. So for example, the TN visa, kind of very strong requirement that you prove you have a residence abroad, you don't intend to abandon. Once you have filed an I-140 petition, you could go to try to renew your TN and they might, deny you. They might say, listen, you just don't meet that requirement. There are strategies you can use. For example, you can, explain, well, I intend to consular process. So in this particular entry, my entry is temporary. Some officers will kind of accept that argument and understand intent is meant to be assessed at every entry. Some officers may say, you want a multi-year visa. I just believe I don't believe you. I don't believe that you really are not trying to come in here permanently. I think you're going to file an adjustment of status. So for these types of visas, always good to kind of maintain your underlying status for as long as you possibly can. So if you can kind of arrange it where your I-140 is being filed after you've renewed your visa, where you still have some time, a few years, that's a more favorable, kind of way to go about it. Always want to consider, do you want to adjust status in the United States or do you want to get that green card through consular processing? Always good to consider kind of what are the timelines at the consulate where I would be doing the green card? What are the timelines, within the US with USCIS? Do I need to travel? Is it going to be a major issue for me if I'm not on an H-1B or an L and I have to wait a year to get advanced parole? So you want to be considering all these things as you consider moving from a visa to a green card. Also consider your family. So do you have children that you want to join your green card application? You may want to file early to avoid any issues with your children aging out of eligibility at 21. So good idea to kind of get that started earlier. All right, so green card interview consideration. So if you are doing a, consular processing, you will always have an interview. If you're doing USCIS, an adjustment of status filing, sometimes you might not have an interview. Again, more and more, almost every applicant is going to be interviewed. Very important to prepare for this interview. Do not just assume that you know everything. Especially because it can be a nerve-wracking situation. You may get a hostile officer. You just want to be very prepared for this to help it go as smoothly as it can. So one, review your immigrant visa petition, your I-140 petition. If there's parts of the PERM that your employer has given you access to, look at those. Review your I-485 or your DS-260 and your kind of NBC submission before the interview. Make sure you're familiar with all the information in it, your employment history, your housing history, what you've written about, your degrees and your background. Organize and print the documents to bring to the interview. You want to bring your originals and then a copy of those originals. So the officer will likely want to inspect the originals. They may ask to keep a copy. They should have this in their files, but sometimes they don't. And you want to have that, available for them. For the I-693 medical exam, this now has to be filed with the initial adjustment application. So, this should have been completed much earlier in the process. For people who are kind of going to their interviews now, this previously wasn't a requirement that you had to submit it with the initial application. So just make sure you have it if you haven't submitted it yet. If you're going through consular processing, you're going to be going to a panel physician, and generally they will give you that notice or they'll send it directly to the consulate. You want to get updated proof of employment from your sponsoring employer. So with USCIS, there's a form called an I-485 Supplement J, where this is either describing, yes, I'm porting to a new job, or I am staying with my same employer. You could also get just a letter on your employer's letterhead explaining, yes, we still plan to offer them this job under these terms as outlined in the labor certification. If you're adjusting your status in the US, also very important that you go over your entire immigration record, like from the first time you started coming to the US up until, now. to make sure that you don't have any immigration violations, or that if you do have any immigration violations, that maybe they can be forgiven under. There's a provision called 245K, where let's say a long time ago, like if there was no grace periods for H-1Bs, and so if you stayed even one day after being fired, maybe you were considered to have violated your status. That's generally a bar to adjusting your status. However, there's a provision called INA 245K where it says, they're only going to look back as far as your most recent entry to the United States. And if you have not, violated your status or worked unauthorized or what have you, for more than 180 days since your last entry, they'll still allow you to adjust status. But it's very important to kind of go over that with your attorney so that any kind of periods of time out of status are explained. It's clear that you want to use 245K, and making that clear to the officer, or that you're able to say, I have a completely clean immigration history. I don't have any issues that need to be discussed. Also good to meet with your attorney and do a practice interview. Just good to practice interviewing, kind of like what kind of questions might you get? Again, you might be nervous on the day. So you want to make sure that anything you're saying is kind of aligned and consistent with everything that was submitted, previously to USCIS, so that you're not having any kind of last minute issues just based on being nervous and kind of saying the wrong thing. Okay, so porting and changing employers. So a very common question we get, during the PERM process is it possible to change my employer? And it's quite difficult to kind of change your employer and take any benefit from it during the first two stages of the process. So let's say your employer has started a PERM for you and you get a different job, you transfer your H-1B to another employer. You don't really take any benefit from that your other employer did a PERM for you. There's really nothing that kind of transfers over in any meaningful way. Let's say that you got to the I-140 stage and you got a priority date assigned and your I-140 was approved for at least 180 days. The benefit here is, you can continue to potentially use that I-140 for H-1B extensions. You do get to keep your priority date. So like later on, if another employer does a PERM for you, you'll get to keep your old priority date. So that can be really nice to allow you to file for your green card, maybe even concurrently with the I-140. So if you do get that I-140 filed and approved, there can be some benefits there, but your new employer is still going to have to do a new PERM for you. However, once you get to the stage where if you're doing an adjustment of status, your I-485 is pending for 180 days, the process becomes more flexible. So flexible in the sense that at this point, you can port to a new job in the same or a similar occupational classification as the job that you got the PERM for. So let's say you got the PERM for the job of an accountant and you really want to, open up a restaurant. That's not going to work. It's going to be hard to argue that you're in the same or a similar occupational classification as a restaurant owner as you were as an accountant. But let's say that, you're an accountant and you get a job as kind of a senior accountant, or a senior, finance person at another company. Then you're going to be in a better position to argue, hey, this is, the same or a similar occupational classification. You're going to provide things like, job description, job duties, job requirements, salary, kind of description of exactly what you're doing as a, in the occupation codes for the government. And then, you can submit that to USCIS and they will adjudicate the case based on this new job offer. And then if it's approved, you can start with the new job. So that's kind of the one circumstance where an employer will not have to go back and do a brand new PERM. So that's obviously, or an I-140. So that's obviously a very big, benefit to that employer. But before you do that, you really want to make sure, will I be able to make a strong argument that this is in the same or a similar occupational classification? Because if they decide it's not, then the case is just denied. All right, changing employers after obtaining your green card, another common question. So especially because this process takes a very long time, kind of maybe even several years at this point with the green card delays and the Department of Labor delays. And, during that time, people may get other job offers. So once you get your green card, hypothetically, the day after you get your green card, you could quit and go work anywhere. That being said, when you apply for your green card, when you attend your interview, you're making a good faith attestation, and so is the company, that they plan to employ you. and that you intend to work in this job as a permanent job in the United States. So immediately leaving your job is, I'd say, not a good idea. There's no kind of minimum requirement of the time you have to stay. Like, let's say you work there for 2 months and your spouse gets an amazing job offer in another state. You can take that, that's okay. But you just want to keep in mind, like, what are the circumstances? Will there be any situation where I could be questioned on this? During the naturalization process is usually when this would come up, where they will kind of look back at what was the basis on which you were granted your green card, what's your employment history, and if they can kind of see, well, you got your green card and quit the next day, that could raise questions for them about the validity of the job offer, maybe, cause them to kind of investigate you a little bit more, maybe the employer a little bit more. So you do want to keep that in mind. And although hypothetically you could leave your employer, the day after you get your green card, a much better idea would be to work there for some length of time, and to have some, relevant explanation for why you left if you leave within a short time frame. All right. So we've reached.
Okay, thank you, Kelly. That was really helpful and very informative. With that, let's go ahead and take a look at questions. Okay, we don't have any questions. That's okay. That's cool. Thank you in that case. Thank you all for joining us. We hope this webinar has been very helpful and informative for you. If you have any additional questions, please feel free to visit our website and schedule a consultation with our team. We look forward to seeing you at our next webinar. Thank you.
Thank you.